Thank you, Your Honor. What you have before you tonight, and I apologize, our attorney on this matter, Danielle Quaid of Hawley Troxel, the law firm that we've retained to move ahead with our judicial confirmation, lives in Spokane, or lives in Coeur d'Alene. On her way down tonight, she got about 5-10 miles out of town. The roads were really slick, so she turned around and went back. So the duty to present this, at least the presentation, falls to me with backup from Les. What we have before us tonight is, you will recall that in the Water Comprehensive Plan that the Council accepted a couple of years ago, there were long-range capital plans within that document. In those long-range capital plans, there were several projects that were identified. One of those being the well number 10 development and construction and attendant transmission piping for that project. And we moved forward applying for a Department of Environmental Quality revolving loan fund loan for that. We were approved for that loan, and within that loan, the DEQ requires that before they will present us with that loan proceeds, we have to show a present ability to accept the obligation. Accepting the obligation means that we have to comply with Article 8, Section 3 of the Idaho Constitution. Article 8, Section 3 states that a city municipality may not incur debt that exceeds the funding in a single budget year unless it is done pursuant to a vote of the people or it is an ordinary and necessary expense. The vote of the people, this would be a revenue bond, and what you need to do to pass a revenue bond is you need to get an affirmative vote of 60%, I believe. Don, is that correct?
Negative 1 over 1/2 of the number voting.
Okay. So, and what it has to do is you have to show that the revenues that you will generate from the utility will amortize the cost of the bond. Judicial confirmation is an alternative to that. What you do is you go to a court and you ask the court to make a determination that the expenditure which you are contemplating fits in as an ordinary and necessary expense of the municipality. Used to be a lot easier. The bonding companies or finance companies did not require a judicial finding that it was an ordinary and necessary expense. What they required was an unqualified opinion of your city attorney that it was an ordinary and necessary expense. That changed in the mid-90s because of some financing around the state by municipalities, and now it is codified in Chapter 7 of the Idaho Code. So what we have before you tonight is in order to find that an expenditure is ordinary and necessary, typically, and I'll hold up the example of the wastewater treatment plant. The wastewater treatment plant has been found to be an ordinary and necessary expense by our local district court because we are operating under an EPA discharge limit, and we are subject to fines if we don't meet those limits. And essentially we have a federal mandate, a mandate that is supported by our own Department of Environmental Quality. And the mandate, we had a voluntary consent order at the time also that indicated or directed that we were not to, if we did not upgrade our wastewater treatment plant, that we wouldn't be allowed to expand or permit any new developments. So the court found that because of those mandates that we were merely complying with the direction of the federal government, and they were rightfully regulating us, that it was an ordinary necessary expense. That same analysis is applied to our water system. One of the things that we'll do, and Les can comment on this as he sees fit, we have regulations for both production of water or provision of potable water to our citizens, also providing fire flow or the capacity of water so that we're able to provide fire protection to our citizens, which is regulated by DEQ in some cases, in the cases of capacity and redundancy, and by the National Fire Code, which has been adopted by the state and the city of Moscow. You'll recall that those of you who are on Public Works Finance Committee, that this was presented probably about 4 weeks ago. At that time, or excuse me, it was pulled before it was presented. The documentation in the packet was presented to council or to committee. It was pulled back because of some question. At that time, we were moving ahead with both well number 10 and with the northwest tank or the northwest reservoir. Because of what turned out to be a faulty standard, if you will, for a finding within the water plan that our capacity analysis did not rise to the level of violating or lacking capacity as dictated by the state, that the northwest tank was withdrawn from the initial petition. And further analysis was done with the engineers who prepared the report, as well as with our engineering staff and the attorney working on the case, that whether there was any other capital improvement within the water plan that was necessary in order to provide that necessary fire flow and capacity of potable water to our citizens. So within that, there were two. One is, of course, well number 10, which is necessary to provide redundancy. It does not, as we're putting in well number 10, it does not give us the ability to fully utilize it to pump more water. What it does is it provides us redundancy for our highest producing well, which is well number 9. It also provides us the redundancy required by DEQ and the National Fire Code to provide fire flow. So that is pursuant to a mandate or a regulation of the state. Secondly, we have 6 pump stations, unless correct me if I'm not using the correct vernacular. We have 6 pump stations that provide capacity and fire flow to 6 different zones in town. Those pump stations are unable to provide consistent volume and pressure of water within those zones to provide the fire protection that is regulated again by the National Fire Code and also by our own fire chief, who sets those capacities as well. So again, these were submitted to our attorney Danielle Quaid and Nicole Pantera, who prepared the petition before you today. The petition, as you can see, is draft. We're not asking that the council approve the petition tonight. The process that we're going through is that the council would dictate or would determine that they wish to move ahead with holding a public hearing on the judicial confirmation in the amount of 4.2, excuse me, I have the number right here, $4.295 million for well number 10 and the pump stations. If the council desires, we will hold a public hearing no sooner than 15 days ahead. So we would currently have it scheduled for January 6th, which is the same night that the newly elected officials are sworn in. What would happen that night is, according to Idaho Code, the public hearing would be held. The council then is not allowed to make a decision on the decision to move forward with the petition that night. They would, no sooner than 2 weeks after that, would then make the decision based upon the information that is presented by staff, our attorneys, and the information within the public hearing. Once that happens, the soonest that would happen would be January 21st. On January 21st, and that would be a Tuesday because of the Martin Luther King holiday, the council, if it decided to authorize the petition would then be filed with the district court. The district court then would move ahead with holding a hearing on the petition no sooner than 30 days after it was filed. Notice would be posted in City Hall 30 days ahead of time. No less than 3 consecutive notices would be published in our newspaper of record, the Moscow Pullman Daily News, also advertising that. To date, I don't believe anyone has filed a request for notice. If a citizen desires notice be mailed to them, they may file that request with the city clerk, and notice will be provided to them separately. So if that happens on the petition, then, if the council goes through and authorizes these successive milestones, then our attorneys and our staff would present the petition or the request for judicial confirmation of the debt. And that's what we're doing here, or we will end up doing if the council authorizes it, is request authority to go into debt for the amount of $4.295 million for well number 10 and attendant piping and for the booster stations. The court then makes their decision, and once that decision is made, if it is a positive decision, then there are 42 days once the decision is rendered. Any citizen has 42 days to appeal the decision or to protest the decision. So in no case would you be able to move forward with incurring that debt and moving ahead with the project until that 42 days passes. The reason that I'm putting all this to you as you kind of put the timeline together is that we have been approved for the DEQ revolving loan fund, and that revolving loan fund has to be accessed by May of 2014. So we're trying to keep the timeline as tight as we can. We also understand that we have a new council that will be sworn in on January 6th. We can provide whatever special meetings or workshops are necessary so that the incoming council and mayor can be briefed on the issues as well, so that the public hearing can occur on the 6th of January. So with that, if you have technical questions about the reasons for the request, you can ask Les. Don's here to answer finance questions, and I'll answer whatever's left.
Thank you, Gary. Well done. And I specifically requested that the workshops or public meetings involving the newly elected council and mayor occur prior to the January 6th meeting at which they will engage in that public hearing. I think it's important to have the background information. Tom?
My question, I think, is a technical question, but it's drafted here as potentially I don't know, a delicacy question or a how will the courts view our request kind of thing. I'm concerned about the reservoir, just within the CCNR. I'm concerned about the lack of inclusion in the reservoir within the application. It would seem to me, technically, that we would need to increase our capacity if the issue is fire flow. And so I am concerned, I just want to make sure, I suppose, that we don't need the reservoir included here as part of the system that we're trying to increase with the 6 lift stations, with the redundancy of the well. If the goal is fire flow, I'm concerned that we don't have enough storage capacity. The only discussion that we have in here about why we're not including the storage capacity is because we think our packet will be stronger as it goes to the judge. That doesn't convince me about the technical aspect of it, and I just want to make sure that. So I just want to bring that back up.